Some new, these are privacy related concerns as well. New legislation on the extent of government surveillance and how it is conducted. The first item is actually not new legislation at all, and that's why it's controversial. It is an administrative change to one of the rules of criminal procedure. The states and our federal government here in the United States have rules that tell law enforcement how to do their job. And one of those federal rules, Rule 41, was just amended, despite the fact that many in Congress thought that this was a pretty sweeping and substantive expansion that required Congress to actually weigh in and consider and vote rather than simply doing nothing and allowing an administrative change to go through. This went into effect yesterday, December 1st, and is now the applicable rule of criminal procedure in the United States. It does a couple of things. It clarifies the law that deals with how judges sign warrants that let authorities access computers by basically hacking into them in areas outside a judge's jurisdiction. It also, and this, in today's day and age, maybe that first part makes some sense, that a judge, if presented with a warrant by a U.S. attorney in one jurisdiction where evidence is being gathered in another jurisdiction, can have the judge right there in her own backyard issue a warrant to do the search. That's not as problematic to me as the second part, which gives federal judges now the authority to issue a warrant to search multiple computers without knowing who is the targeted computer owner. So that seems to me problematic in coming up with probable cause, which is what judges have to know is present before they go ahead and issue a warrant in a search warrant in the first place. So we'll have to see if there are challenges to this rule. I'm sure that creative civil rights activists and others are already thinking about if it is applied broadly and unidentified persons are having their computers searched via warrants issued under this rule. I think we're going to hear about it in the future. Mike, have you looked at this?
I did look at it, and I was really surprised by this development. I had not been aware of it until I was reading the show notes. So what's particularly striking is, as you mentioned, this is a procedural rule. This is something that was put together by an advisory committee and ultimately approved by the U.S. Supreme Court, not elected officials. They're, of course, judicial officials that govern various aspects of the federal judiciary. So this sounds like a fairly significant substantive piece of law that actually comes into play not through the legislative process, but through the judicial process. And what seems particularly striking about it is what you mentioned, Denise, that under the Fourth Amendment to the Constitution, in order for a warrant to issue, you've got to have particularized suspicion, and you've got to be able to articulate what you want to search and what you want to seize, and you need to convince the court that there's a reasonable basis for that request. It seems like this creates a procedure whereby you don't necessarily have to have this particularized suspicion or know the individuals whose computers are going to be searched and hacked. So it seems rather sweeping. I'm not at all surprised to see that the Electronic Frontier Foundation is opposing Criminal Procedure Rule 41, and we'll have to see if there's going to be any judicial challenges to it.
Right. And I think another takeaway for folks watching is how this underscores the importance of the judiciary in our country and the discretion that judges have. And so how important it becomes that we put good, competent, thoroughgoing, rationally thinking, logically thinking judges on the bench and not folks who would be inclined to issue a search warrant without giving it the proper attention that it deserves, because they are really the last line here in how this rule is applied and how they decide whether probable cause is present or not. So when you're being called upon to help decide what judges are going to represent you in your local elections and stuff, bear all that in mind. Jessica, any thoughts?
Just tying on to that, my first thought when I saw this about judges being able to sign warrants outside of their own jurisdiction is it basically did bring to mind kind of the forum shopping idea that, you hear plaintiffs' lawyers accused of forum shopping, looking for the judges or the forums that are going to be most sympathetic to their case. Mm-hmm. My concern here is that obviously not that the government would hopefully ever short circuit anything, but that they would kind of start to rely heavily on a few judges that they know may be less inclined to give kind of the strict supervision that's warranted when issuing these warrants. So that was my first thought. But I agree with you that the second part about not even having to know who's, I guess, the target of these does give a lot of concern about how much supervision the court can actually give to these activities then.
Right. And back to my point about who actually is sitting on the bench, federal district judges are not people that you get to weigh in about. You at least here in California, we can weigh in on our local superior court judges, who are generally the people who go on to become appellate court judges and Supreme Court judges. But federal judges, who are the folks who will be applying this Rule 41, they're appointed by the President of the United States. So, not only is it important who gets appointed to the Supreme Court, but every federal judge is appointed by the president. So, something to just bear in mind, too.